in this matter, Lordship.
Yes, who is for the petitioner?
Milord, I am for petitioner, Milord.
बताइए.
Milord, in this matter, Milord, Senior Counsel Sri B.K. Tankha will appear, Lordship. So this matter may kindly be list and other bench on Monday, Lordship.
Oh, is there a power filed?
Milord, the connected matter, I have filed the order sheet. Annexure P7, Milord. The lead case WP 807, Lordship. Because in this matter, Milord, the relate to the PSP examination 2019, Milord. The in this petition, Milord, the annexure P1 preliminary result and mains result of the examination 2019 has been challenged, Milord. The earlier petition WP 807, Milord. In this petition, the rules, amended rules 2015 and result of preliminary 2019 has also challenged, Milord. The rule has been repealed by the government in 2012-2021, Milord. Thereafter, the mains examination result has been declared in 31/12/2021, Milord. So in this matter, Milord, the repealed rule has been applied. And the said rule itself, since beginning, Milord, against the Constitution, Milord. These rules provide the communal reservation, which comes 113%, Lord, sir.
That's beyond 50%.
Yes, Milord. These rule is restraining to the meritorious reserve candidate for migrating open category. So I have challenged the constitutional validity of these rules, Milord, along with WP 807/2021, Milord. The Honorable Court has passed the interim order on 27/1/2021, Milord.
The appointments have been made.
During pending of this writ petition, Milord, the state government has repealed this rule 2012-2021, Milord. Since beginning, Milord, Sri Senior Counsel Tankha ji appearing, Milord.
What is the problem?
Problem, sir?
What is the problem if he appears?
Milord, I have no problem, Lord, sir.
Where?
इसमें तनखा जी आर्ग्यू करेंगे तो मंडे के लिए
My policy of recusal is very strict. I don't recuse easily. If the lawyer wants to recuse, he can.
ठीक है सर, सुन ले, मैं सुना रहा हूँ आपको बहस पूरा। ठीक है सर। मैं kindly see, Lord, sir, annexure. Before arguing, Milord, I have arguing some history of this case, Milord. The PSC issued the advertisement for recruiting the post of State Administrative Service in 14/11/2019, Milord. And the examination for plenary examination 2019 has been conducted 12/1/2020, Milord. The state government has amended rule annexure P3, page number 35, Lord, sir. We kindly see.
35. Yes.
17 February of 2020, Milord. In this rule, Milord, I have challenged the constitutional validity of this rule, Milord. These rules provide
what is the amendment? You please read that particular portion.
Milord, may kindly see page number 35.
Yes, P3.
Rule 4, Lord, sir.
Rule 4 is page 36. What was
this rule is restraining.
Rule
to
4
the
is
meritorious candidate in the pre
Rule 4 has
examination.
been substituted by this new rule.
Milad, the old rule is Annexure P4, page 44, let's say. Original rule.
P4. Where is Rule 4? Page 48.
Yes, Milad. Mode of preparation of select list.
So what is the change?
Milad, this rule is permit to the meritorious candidates for migrating in open seats, unreserved seats.
Where is that?
The amended rule 17 February 2020 is returning to the meritorious candidate for unreserved seats.
So where is that restraint? Please point out in the amendment 36.
Milad, this rule has repealed by the government. I have filed the amended rule.
Amended rule is at page 36. Where is that restraint? In 36.
Milad, mode of preparation of the select list. On the basis of marks obtaining in the preliminary examination, category-wise candidate numbering 15 times of the vacancies as advertised will be declared unsuccessful for main examination subject to the candidate. That candidate have scored minimum passing marks as may be specified by the commission. In addition to this, all the other candidates who get marks equal to cut-off marks will also be declared successful for the main examination. Number 2, separate lists in the candidates applied in the unreserved scheduled caste, scheduled tribes, other
कहाँ
backward.
पढ़ रहे हैं आप? कहाँ पढ़ रहे हैं आप?
Page number 36, rule 4, 2. Rule 4, 1A, cut 2.
Yes.
The separate list of the candidates applied in unreserved scheduled caste, scheduled tribes, other backward classes, and economical weaker section shall be prepared. Reservation shall be given to women and ex-servicemen in all categories as per rule and instructions issued by this regard from time to time. And seek up first. Seek up first last mechanism for the post advertised for the various category for persons with disabilities, visual or low vision, hearing or low hearing, locomotor disabilities, multiple disabilities candidates numbering 15 times of the vacancies advertised for such persons with disabilities category will be declared successful for the main examination subject to the
Mr. Thakur, please point out that particular provision which you are challenging. Don't read the entire book.
Rule 4, Rule 4, 1 cut 2 is saying separate list.
Yes.
मतलब जिस कैटेगरी में जिसने अप्लाई किया है वो उसी कैटेगरी में रहेगा, सेपरेट लिस्ट इसका मीनिंग। जबकि जो अनरिजर्व सीट्स होती हैं, अनरिजर्व सीट्स का जो मोड है उसमें मेरिटोरियस कैंडिडेट्स ही माइग्रेट करते हैं, चाहे वो किसी कैटेगरी के हों। इन्होंने पीटी के रिजल्ट में ऐसा नहीं किया। जो प्रारंभिक परीक्षा का रिजल्ट इन्होंने डिक्लेयर किया है उसमें इन्होंने जो मेरिटोरियस कैंडिडेट हैं ओबीसी के, एक भी कैंडिडेट को मेरिट के आधार पर अनरिजर्व में माइग्रेट नहीं किया। तो जो कट ऑफ मार्क्स हैं उनके सेम है, अनरिजर्व का 146 है और ओबीसी का भी 146 कट ऑफ है। इनका कहना यह है कि हम फाइनल आफ्टर इंटरव्यू देखेंगे, जबकि रूल स्पेसिफाइड बोलता है, इंदिरा साहनी का जजमेंट पैरा नंबर 812 कि जो अनरिजर्व सीट्स हैं किसी भी स्टेज में हो, अनरिजर्व सीट्स में केवल मेरिटोरियस कैंडिडेट्स ही सिलेक्ट होते हैं। इन्होंने इन नियमों को बदल दिया, चेंज कर दिया जबकि पुराने रूल इसको परमिट करते थे। ये रूल अप्लाई इन्होंने पीटी 2019 जो 21/12/2021 को घोषित हुआ है उसमें अप्लाई किया है। जो मैंने इसमें लगाया हुआ है सर रिजल्ट में काइंडली सी पेज नंबर 26।
Who is defending the state?
Mr. Ashish Bernard.
Mr. Bernard, could you understand what he is saying? I couldn't. I could not.
If I may just explain, Manoj, what my learned friend basically is aggrieved about, Manoj, is that in the results which have been declared by the Public Service Commission, the migration during the shortlisting, Manoj, preliminary and main examination, the migration of reserved category meritorious candidates is not being permitted in the results which have been declared. Now, my learned friend, Manoj, I'll just give a background now what has happened. Manoj, my learned friend was referring to WP 807.
When you say migration, what do you mean?
Manoj, what is happening, Manoj, is that the provision, Manoj, reservation was being applied right at the time of final selection, as per previously, Manoj. That is once the final selection at the interview stage, finally it happens. But now, right now, we have a 3-tier examination process, Manoj, where in preliminary stage, we are shortlisting. Then the candidates who clear the prelims move to the main examination. And then from mains, you come to interview and so forth. The quantum of candidates who are moving was that, assuming, Manoj, there are 10 lakh candidates who applied for a preliminary examination. Now, in the total number of seats to be selected are 100. Yes. 15 times of the total seats, that time the reservation was not being applied, 15 times of the total seats were being called for the main examination. So about 1500 students would come for the main examination. My learned friend's contention is that what he said, which they challenged in the WP 807 was that, look here, when you are getting these candidates in the shortlisting process from prelims to mains, you should apply reservation at that level itself. So and then when you, so in that pool of 15 times, you have to have your, the total pool of 1500 should have, Manoj, the reservation quota of 16%, 10%, 27% and all that. Similarly, when you take those in your main exam, when you go for the interview, you will take 3 times you take or 2 times if you take. So if you're taking 700 candidates for the final interview session, then when you take those 700 in that pool also reservation should be applied. And then the final selection. Now, the earlier rules were different, and my learned friend Manoj had a bunch of petitions. They had challenged it in WP 807. Manoj. The state government, Manoj, we considered all the aspects, Manoj, and the state learned state government, Manoj, said that yes, there is some merit in it, and we amended those rules, and that amendment happened on 21st of December 2021.
P6 page 64.
20th of December 21. When
17th February 20 P3.
That was the amendment which was challenged previously, where that migration was not allowed, which my learned friend refers to as migration of meritorious reserved category candidates. Okay. Then we considered, Manoj, the submissions and all, Manoj, and the state government, Manoj, amended that rule itself by repealing it by this amendment of 20th of December 21.
Where is that?
Manoj, that 20th of December.
Page number 64.
64.
Yes.
And if my lord will come to the English version, Manoj, my lord can come straight away to page 69.
69 पे translate वाला.
69, the English translation, Manoj. My lord may have the amendment, and my lord may look at K. What we did was we expanded the definition of unreserved category by saying unreserved category includes candidates belonging to the reserved categories, scheduled castes, scheduled tribes, OBCs and EWS who have not availed benefit of relaxation.
Yes.
There is no grievance to this amendment.
Hmm.
The grievance which my learned friend Manoj is saying is that now the PSC has declared the results of the examination conducted in 2019 on the basis of the unamended rules.
Yes.
So my learned friend's grievance is that it should have been done as per these rules, which came in December 21, and not as per the earlier rules which you have repealed and amended by this. That is
When was the advertisement issued?
the advertisement was issued. I'll just give the date. The advertisement
14/11/19 को सर
14th of November 2019.
P5
Preliminary examination was held. I'll just quickly give the dates. The advertisement was issued by the PSC on 14th of November 2019.
Yes.
Preliminary examination was conducted on 12th of January 2020.
Yes.
On 17th of February 2020, we did that amendment of which we have now repealed.
Yes.
The results of the preliminary examination were declared on
21/12
on 21st of February, on 21st of December 2020.
Yes.
Then in February of last year of 21, these bunch of petitions came challenging the vires of the 2020 amendment, which I just pointed out.
Yes.
And now, we've repealed that amendment by amended, substituted, amended by this second amendment of 20th of December 21. So the grievance, of my learned friend, I may be corrected, if I've understood it incorrectly. But the grievance is that the result by the PSC should have been declared as per the 2021 amendment.
No, what was the rule position when the advertisement was issued?
When the advertisement was issued, that time even the 2020 rules were not there. But what was holding forth? Were the enactment of the Madhya Pradesh Lok Seva Anusuchit Jati 1994 Act, the main act, and two judgments of this honorable court, one of Hemraj Rana, which is reported in 2006, volume 3 Mppsc, page 477. Where the Honorable High Court, the Honorable Division Bench of this High Court, interpreted the word selected as given in section 4, subsection 4 of the 1994 Act. If I may just read that Act, I'm just pointing out the factual position, what happened.
Yes.
If I may just read, this is the Madhya Pradesh Lok Seva Anusuchit Jati, Anusuchit Janjati और पिछड़ा वर्ग के लिए आरक्षण अधिनियम 94. Subsection 4 of section 4 of this act says, section 4 deals with fixation of percentage of reservation of posts and standard of evaluation. Subsection 4 says, if a person belonging to any of the categories mentioned in subsection 2 deals with SC, ST and OBC, gets selected on the basis of merit in an open competition with general categories, he shall not be adjusted against the vacancies for such category under subsection 2. Now, the meaning, the interpretation of this fell before this honorable court in this first judgment of 2006. Reported in 6477. Where the honorable division bench then Chief Justice Naik as then honorable so I'll just read para 5. Do my lords have a copy of that judgment?
Para 5.
It begins with subsection 4 of section 4 of the Adhiniyam, and then they quote that. My lords have that?
Hemraj Rana's case.
Hemraj Rana, Hemraj Rana.
Para 5.
Yes, my lords have that subsection 4 of section 4.
Para 5 starts with, it will be clear.
I'm sorry. Oh, I'm sorry, my lords. I have the MP weekly notes.
No, yes, you are right. Hemraj Rana is, yes, subsection 4 of section 4, yes.
So in para 5, they quote subsection 4 of section 4 of the Adhiniyam, on which the great reliance has been placed, is quoted as herein below. And then, my lords, after the reproduction of the Act, my lords may find the language of the said subsection 4 of section 4 of the Adhiniyam of 1994 makes it clear that if a person belong to any of the reserved categories gets selected on the basis of merit in an open competition with the general candidates, he shall be adjusted against the vacancies meant for general candidates. Now, this is important, my lord. The word selected clearly indicates that subsection 4 of section 4 of the Adhiniyam 94 will apply only at the time of final selection of the candidates and not at the time of preliminary examination. So, Malad, this judgment, Malad, was holding forth. This had interpreted, Malad. Then, Malad, what happened, Malad? Moving chronologically, Malad, in 2015, Malad, we framed these rules, Malad, which are there, Malad. The Madhya Pradesh State Service Examination Rules 2015. And as my learned friend Malad pointed out, that in those rules, Malad, we had simply if my lords will have that rule, Malad, I'll not burden my lords with the pages, Malad. In that rule, Malad, we had simply said mode of preparation of select list. We said that a preliminary examination, candidates numbering 15 times the vacancies as advertised will be declared successful. So no reservation was applied at that preliminary stage, Malad.
That was in line with this Hemraj Rana.
Hemraj Rana, Malad. Now, thereafter, Malad, what happened, Malad? There is another judgment of the Honorable Bench at Indore, Malad, in Vishal Jain's case, Malad, which is of 1st of February 2019. That, Malad, is WA number 1450 of 2018, Malad.
Order on record.
No, Malad, it's not on record.
My lord, that judgment is along with my intervention application as annexure T2. With my intervention application, I have annexed that order of the Honorable Division Bench, Your Lordship, 1450 at page number 11.
I'm only pointing out that the Honorable Division Bench at Indore considered Hemraj Rana in this judgment and said that, yes, Hemraj Rana has said that it shall be at the final stage. If I may just read, they quote that and they say that, well, it shall be at the final stage. This is what was the field, my lords, and then the advertisement comes, my lords, of the PSC in November of 2019.
Yes.
We make Malad, this amendment, the first amendment, if I may call it, Malad, the first amendment we make on February 2020, where, Malad, we follow the ratio and the directions given in Hemraj Rana and Vishal Jain, Malad, this 2019 judgment. Then, Malad, comes litigation, Malad, to this honorable court, where Malad WP 807, my learned friend Malad, appears for the petitioner, and we can reconsider that, Malad, that yes, we need to reconsider this issue, Malad. And then, Malad, we issue this amendment, which my learned friend pointed out, Malad, in December of 21, where we, Malad, now with this amendment, we said that yes, unreserved categories would include SC, ST, and OBC. So therefore, Malad, they will be counted at the preliminary, at the shortlisting stage. So when they move from prelims to mains, so that reservation will be done. But my learned friend, Malad, is perhaps, if I have understood it correctly, Malad, my learned friend is saying that it should have been done. It's not been done for the previous examination.
But it has to be the assessment is issued. The rules applicable at the time of advertisement have to be applied.
Well,
That seems to have been done. Or not?
yes, Malad. We Malad, at that time, Malad, if we look at the date of exam rule, date of advertisement, Malad, that is November 2019.
Yes.
Was holding the field were two judgments of this honorable court, Malad. Hemraj Rana of 2006 and the February 2019 order, Malad, in Vishal Jain case.
Yes, and they said that the select in different categories would be prepared only after the final.
At the final stage.
After the interview.
Yes, at the final stage.
Yes, Mr. Counsel, then what is wrong with the. What is wrong?
Milord, it is completely wrong, Milord. There is no question of reservation. The main question is that what is the manner to fill up the unreserved seat in the preliminary examination as well as main examination.
My learned friends,
We are
voice is
reserving those seats
Your
to the
voice
backward
is,
category.
your voice is echoing.
Yes, lots of. Clear are you?
No, they seem to be applying the rules which were prevailing at the time when the game began. That is the advertisement.
Yes, Milord. This is also the question in this petition.
PSC
This
has
rule is enacted in and amended 17 February 2020 and advertisement November 2019, Milord. Exam had already conducted in January 2020 and rule has been applied while preparing the result.
The rule which was prevailing in November 19 has been applied. Is it not?
Yes.
What is wrong with it?
मिलर वही बात मैंने बोली है कि ये रूल रिट्रोस्पेक्ट ऑफ फैक्ट से लागू नहीं होंगे।
वो नहीं कर रहे हैं उसको, लागू कर रहे हैं क्या आप लोग?
मतलब लागू कर दिए जो रिजल्ट इन्होंने डिक्लेयर किया है पीटी का जो इसमें अप्लाई किया है इन्होंने।
No, on this selection लागू किया है क्या which had begun in November 19?
But actually the rules of 2020 have been applied, my lord, for declaring the result of preliminary examination, my lord, because of the fact that while we issued the advertisement, my lord, in November 2019, my lord, there were rules of 2015. That is okay, my lord. But my lord, then the exam was conducted in January and the rules were amended in February 2020, my lord. But there was a decision of the Mantri Parishad, my lord, which said that these rules, amended rules, will be applied from the exam of 2019, my lord. And my lord, the difficulty is recently we have declared the results of mains examination 2019, my lord, which is the question in this petition, my lord. My lord, we have only declared the results of 2019 mains according to those rules because, my lord, we have applied those rules for pre-examination, my lord. Now, my lord, if we applied one set of rules for pre-examination, then we cannot change the rules for mains, my lord.
That means you applied the rules to the preliminary examinations which were prevailing or which came into being after the advertisement.
My lord, after the advertisement, but before the declaration of the result, my lord.
How can that be?
My lord, because there was a specific decision of the Mantri Parishad, my lord.
Mantri Parishad cannot be above the law. The law is that you cannot apply a rule which was not existing at the time of the advertisement. Subsequent amendments will not make any difference. You can apply it to the subsequent advertisements issued after the amendment, not the advertisements which were issued prior to that.
My lord, actually the advertisement was issued in 19, but my lord, at the time we declared the result, the 15 rules were not also in existence, my lord.
What is the law? What is the law? What is the law?
My lord, the law is that we should apply the rules which were prevalent at the time of advertisement, my lord. But the judgment in Mppsc Kumar provides that, my lord, that if there is a specific implication of subsequent amendment, effect of amendment, then we can apply, my lord.
Where is that?
My lord.
When you file a reply, we'll see.
Your Lordship, we are on behalf of intervention, Your Lordship. Intervener, Your Lordship. I filed the application for intervention, Your Lordship.
Who are the interveners?
My Lord, intervener is a person who has been selected in the main, Your Lordship, and he is waiting for his interview call.
All right, we'll hear you. Whenever required, we'll hear you.
My Lord,
Uh,
my Lord, the issue is, may I make submission, Your Lordship?
We'll hear you. You have no right to any relief. You only have a right to audience whenever the court permits you.
Yeah, my Lord.
This court is very
Manoj,
gracious and gracious, Manoj, and my learned friend will be granted an audience. Manoj.
But my Lord, without making the party to the selected candidates, Your Lordship, the petitioner cannot come up with this case, Your Lordship. Because the rights of the selected candidates will also get affected, Your Lordship.
Those rights mature only when the appointments are issued, not prior to that.
My Lord, our rights will get affected, Your Lordship. In that case, my Lord, if any relief will be granted to the petitioners, Your Lordship.
A selectee, merely because his name is there in the select list, has no right to appointment. You know that. You know that.
My Lord, my Lord, my Lord, my Lord.
The case, man. Let notice be issued on the payment of TF within 7 working days peremptory.
Milord, notice has already been issued by the Honorable Court, Milord, on 4/2/2020.
There is no notice issued. Let notice be issued on payment of PF within 3 days. 7 working days peremptory. Let response be filed within 8 weeks. The IAS also for intervention has been filed by a selected candidate.
My Lord.
Who shall be heard as and when required. Next, the IAS kept pending. Next. Any appointments made shall be subject to the final outcome of the petition.
Milord, may kindly be stay, Milord. The interim order is already in the other petition 27 January.
No, Your Lordship, there is no interim order, my Lord.
Selections will not be stayed. They will only be subject to. We can't stay the entire selection just because of your petition.
Milord, they are proceeding of illegal rules, Milord.
If you want, we can reject your interim relief if you press for it.
Milord, I am seeking to extend the entire selection process in subject wala order.
Whatever happens, finally we'll decide. Whatever happens, finally we'll decide.
Milord, fixed date दे देना सर, fixed date दे देना.
जवाब आ जाए उसके बाद दीजिए, अभी नहीं.
सर इसमें तारीख नहीं लगेगी सर, कोई भी कृपया इसको कोई भी वीक कमीशन देना सर.
इसमें अर्जेंसी क्या है?
अर्जेंसी सर ये है कि प्रोसीडिंग डे टू डे आगे बढ़ रही है और प्री रिजल्ट के बाद ही इसमें चैलेंज किया था और 27 जनवरी को अदर रेट पिटीशन में सब्जेक्ट टू फाइनल आउटकम वाला ऑर्डर है ऑनरेबल कोर्ट का. इसके बावजूद भी इन्होंने मेंस एग्जाम कंडक्ट कराया है.
वो तो कराना चाहिए, जल्दी कराना चाहिए उनको तो. Nothing should stop. The system will not stop because of one petition. System has to go on.
लेकिन system should be acted accordance with the rules, Milord. It is not according in the unconstitutional rule, Milord.
We can't stay it. We can't stay a process which has started 2 years back, 3 years back.
Milord, those candidates who are preferred this petition, Milord.
The council, do you want me to reject your interim prayer on?
I am seeking
by speaking order.
Milord, I am seeking the final order, Milord.
Final order cannot be passed at this stage when there is no reply on the other side.
Milord, reply has already been filed by the respondent in the other petition. This petition may kindly be linked along with WP 807 Lordship. इसको नेक्स्ट वीक कर दें आप उसमें
807 के साथ लिंक कर देना इसको.
नेक्स्ट वीक कर दें सर इसको प्लीज.
लेट द रिप्लाई कम.
रिप्लाई है सर, पीएससी का भी रिप्लाई है उसमें, स्टेट का भी रिप्लाई है, कोई उनका नया कंटेंशन नहीं है सर. वही कहना है जो इन्होंने रिप्लाई में कह दिया वही अभी बोल रहे हैं लोग. तो इसको नेक्स्ट वीक कर दें, मंडे को या ट्यूसडे को. 807 के साथ में। लाखों बच्चों की जिंदगी का सवाल है सर इसमें।
The council, we've heard you and we passed an order. If you agreed by it, please challenge it.
नहीं, लॉर्डशिप डिले जस्टिस डिनाई जस्टिस, यदि समय पे जस्टिस नहीं मिलेगा तो बाद में यदि ऑर्डर भी होगा कोई मतलब का नहीं रहेगा इन बच्चों के।
Right, we have a right to pass a wrong as well as a right order. If you agreed by a order, please go ahead.
Milord, I am requesting Milord, this matter may kindly post in next week along with WP 807/2021, Milord.
No, we have listed along with that, but not next week. Whenever it is listed, we don't know.
आफ्टर वीक कर दें सर, आफ्टर वीक कर दें।
आप नोटिस पीएफ दीजिए ताकि फॉर्मली जवाब आ सके, फॉर्मली ओआईसी अपॉइंट हो सके। नोटिस हैज नॉट बीन इशूड इन दिस केस येट।
हम दे चुके हैं एडवांस कॉपी, पीएससी और 2 रिस्पोंडेंट हैं, दोनों को एडवांस कॉपी हम दे चुके हैं।
देयर इज नो रिप्लाई ऑफ द पीएससी येट।
पीएससी ने रिप्लाई फाइल किया है सर।
मिस्टर काउंसिल, विल यू अलाउ मी टू टेक अप द नेक्स्ट केस?
मिलर्ड में काइंडली
प्लीज मिस्टर काउंसिल, मिस्टर ठाकुर,
आफ्टर वीक कर दें सर इसको, आफ्टर वीक कर दें।
Please call the next case, 46.
46 the